In view of the aforesaid facts and circumstances, we are of the considered opinion that
Appeal is allowed.
leaked already. Wrong information. That this case would not be sufficient. The materials in this case would not be sufficient to come to a conclusion of guilt, and the same has been proved beyond all reasonable doubt. We are of the opinion the benefit of doubt has to be given to the appellant. Accordingly, we set aside the judgment. We render our we record our appreciation for the amicus. Okay.
Let's now, please, Your Honor, I beg to mention item number 3.
3 years.
The English Council, Your Honor, is not doing well. He's sick. So the matter may kindly.
Who, SK Nargis?
Yes, Your Honor.
On a prayer, but 17 matter, NCB. Hearing, okay, on. Okay. On a request made on behalf of the learned counsel for the appellant who is stated to be unwell, matter is adjourned by a week. Sri S.C. Kyle Leonard, standing on NCB, is present. Yes.
Keep your pipe.
May I please, Your Honor? So if I beg to mention item number 2,
Yes.
Jeff Summer, learned senior counsel, it's not personal, it's not appear related.
Okay. On a request made on behalf of the appellant, matter is adjourned to be listed after a week. Yes.
Complex.
Please, Your Honor.
Yes, please.
I'm seeking adjournment on regarding item number 5. There's some personal difficulties.
Item number 5. Yes. What is the difficulty?
There's some personal difficulty.
On a request made on behalf of the appellant, the matter is adjourned to be listed after a week. Item 5.
Blind.
Item 1.
In this matter, I'm appearing for Mr. A. Alam and the other English Council, Your Honor, Mr. J. H. Khan, he expired. Your Honor, this particular appeal arose consequent to the acquittal of the accused by the learned additional session judge Hojai. And after hearing the parties and trusting the record, this honorable court reversed the judgment and he was convicted actually. But as the learned additional session judge acquitted, so the statement of the accused under 313 CRPC could not be recorded, Your Honor. So this honorable court directed the learned trial court to record the statement.
What had happened thereafter?
We have not received any information, Your Honor, if the statements are recorded as of now.
There is no such indication. Where is it?
Your Honor, this what I was directed as my senior.
Is there any such indication? What was the judgment by the Honorable Supreme Court? This matter had gone before the Honorable Supreme Court.
Probably.
Where is the aspect of 313 which you had just mentioned?
From where do you get that? Is there anything? 313?
So now it should be in the record. This part I have been directed by my senior.
Madam, check the record.
I'll check.
Be here for some time. We'll have it after some time.
Good.
এখানে আছে এখন নালাগে বাৰু ৰেকৰ্ড হেৰি আছে Next.
Four, I think four.
Dear Lordship, the appellant is convicted under section 302 for life imprisonment. And he was acquitted from the charges under section 304B and 498A. And the victim was his wife, Lordship. And what I find subject to correction, Lordship, that in the instant case, he is convicted basically because, Lordship, he was the husband of that. Apart from that, there is no material in the present. Even the father who was examined as PW2, he says there was cordial relation, there was no torture, and only because of suspicion this affair was lost. Those things were stated by him, but the learned trial court rejected his evidence on the ground that subsequently the appellant remarried the sister of the deceased.
You can hear this. How many?
9 witnesses.
9.
9.
You can hear this. I think. We can leave. Yes, we can. We'll hear this. Who will be appearing, Madam Begum? Okay. In the meantime, Bhuya, you look into the records in that case. That submission, that information we have not been able to find. 313. That we have seen. Where is the requirement of 313? That remand. Supreme Court we have seen. It's a regular appeal, Mr. Ahmed.
Regular. FIR, your Lordship will find page.
Yes, please. Please proceed.
FIR was lodged by maternal aunt of the victim. Page 3. I have the honor to state that Miss Nurada Khatun is my sister's daughter. She was married off to accused number 1 about 5-6 years back. The accused persons used to torture my niece with regard to dowry since after that marriage. At about 8 a.m. today, that is 5/10/2017, the accused persons poured kerosene on my said niece and set fire to her with an intention of killing her, and consequently her entire body got burned. Presently, she is under treatment at MCH. Thereafter, moreover, it is mentioned here that her parents went to Karnataka to do daily wage work, and that I have been compelled to lodge this Azahar on being ordered by them. I therefore earnestly request, so this was the FIR, and it was registered initially under section 498A IPC.
At the time of lodging of the affair, she was still
Still
alive.
alive.
Still alive. Hmm.
She was undergoing treatment, but on the same day she died.
She ultimately passed away when?
On the same
Same day
Yep.
passed away.
In the FIR, two persons were named, and while submitting charge sheet, the present appellant was the only accused, the sister. That charge sheet your lordship will find page 87, and charge sheet was submitted under section 498A, 304B, and 302.
Hmm. Charges were framed under 302 and 304B.
Yes, and 498. Charges were framed that charge framing had your lordship will find page 5.
Yes, yes.
After trial, he was acquitted from the charges of 304B and 498A. He was acquitted.
Convicted under 302.
But
Okay.
evidence of PW1, your lordship will find at page 8.
The informant.
Lord, maternal aunt of the victim.
Yes, please.
I know the accused. I am the complainant. It is about 10-11 months of lodging of the Azahar. It has been about 5-6 years since my sister's daughter Nureja was married off to the accused. Around 8 o'clock, when I was at my home, my younger sister Kudeja informed me over phone that a quarrel had taken place between her daughter and son-in-law, and asked me to go to their house. And I told her that I would go after taking tea, and I hanged up the phone. After some time, my sister again rang me and told that his son-in-law had set fire to her daughter by pouring kerosene on her. Immediately, I, along with a woman, Manju, by name from Besimari, went to the house of the husband of my niece, situated at Dolgaon, and learned that my niece Kudeja was taken to Mongaldoi Civil Hospital. The villagers of the village of my niece's husband told me to go to the hospital immediately, otherwise I might not find her alive. Immediately, I went to Dolgaon police station, got an Azahar written by a person, and put my thumb impression on it. So before Pratik inquired from the victim, she immediately went to the police station and lodged the present case without knowing the actual fact from the victim. When I was in the police station itself, I was informed over phone that Nureja had died. Nureja's father, Nur Islam, called me over phone and gave the information. Thereafter, I went to Mongaldoi. Nureja was taken to Guwahati before I left, but as she had died on the way, she was again brought back to the hospital by the vehicle, and I saw her dead. I found the entire body of Nureja burned. Police took material exhibit 1, 2, and 3 after the death of Nureja. The villagers told me that Nureja was assaulted when a quarrel took place between Nureja and her husband of my niece. prior to the incident, and that later on the husband of my niece accused set fire to her by pouring kerosene on her. Nureja had 2 sons. Prior to this incident also, Nureja came to our house when her husband assaulted her. Later on, I counseled them and left her in her husband's house. I do not know what the quarrel took place for. Cross. I was not present in the marriage between Nureja and the accused. Presently, the elder son is about 5 years old. I do not know how long it had been since the marriage between Nureja and the accused at the time of incident. I do not know what the quarrel took place for. I did not witness the incident. My sister Kudeja informed me over phone from Karnataka that quarrel took place between Nureja and her husband at the time of incident, and asked me to go immediately. The husband of my niece and his relatives took Kudeja to Mongoldo Civil Hospital. So, Lordship, may kindly note this part. The husband of my niece, that is the appellant for your Lordship, and his relatives took Kudeja to Mongoldo Civil
Why
Hospital.
Kudeja?
Lordship,
This should be Nureja, I think.
Kudeja is the
Mother,
yes,
not the victim.
that Kudeja's husband. That is Nure. It should be Nureja.
It should be Nureja, I think.
Nureja, but it is written as
Nurada,
Kudeja.
Nurada.
Yes. The fellow villagers of Nureja's husband told me about the incident. I got tense and first I went to the police station and lodged an Ajahar. After the death of my niece Nureja, I did not. Could be Nureja.
Everything Kudeja has come. Why? Record
Probably it is typographical error.
record to some. No, it is type copy. Let us see. Record to.
Kudeja is the mother of Nureja.
No, that is the sister
Not.
of the informant, younger sister. I think the translation is incorrectly done. Yes. No, it's written right, this one. Khudeza Juhai. That means the son-in-law of Khudeza and Juhai Manu and his relatives. Moholdoi Hospital of Nisiri. I think the victim has not been named here. Khudeza Juhai and his people had taken her to. Obviously, the victim. Very bad. A Jabbar. Answer Kankana Bora Archana Devi. Thundam. You can read the original.
Okay.
And listen. It's in vernacular, only that part. Because first part, it is the type portion. It is not even typed, it is translated. The cross-examination part. Have you got? Khudeza Juai.
Khudeza, নুৰেজাৰ may I read?
Yes, please read.
নুৰেজা আৰু আছামীৰ লগত বিয়া হোৱাত মই উপস্থিত নাছিলো।
Hmm.
বৰ্তমান ডাঙৰ সন্তানৰ বয়স 5 বছৰমান হ'ব।
Hmm.
ঘটনাৰ সময়ত নুৰেজাৰ আছামীৰ লগত বিয়া হোৱা কিমান দিন হৈছিল নাজানো। কি কাৰণে কাজিয়া হয় মই নাজানো। মই ঘটনা দেখা নাই। ঘটনাৰ সময়ত নুৰেজাৰ স্বামীৰ লগত কাজিয়া লগা কথা কৰ্ণাটকৰ শুনি খুদেজাই ফোন কৰি কয় আৰু তাড়াতাড়ি যাব কয়।
Hmm.
খুদেজাক জোৱাই আৰু জোৱাইৰ মানুহে
This part.
Yes.
Khudeza Juai. It is not Khudeja who has been taken to the hospital. It is the son-in-law of Khudeja. That is mother of the victim. Okay, leave aside. We will rectify the. It's not been translation has not been correctly done. Nonetheless, can you go forward with the paper book? Let's hurry up. Record of it. Not like that.
probably because that Khudejar that in last that line is there. Therefore they have
Okay, then please proceed. Then I got tensed
I got
as the fellow
Yes.
villagers.
as the fellow villagers of Khudeja's husband told me about the incident, I got tensed and first I went to the police station and lodged an Ejahar.
Hmm.
After the death of my niece, Khudeja, it should be niece, Khudeja, I did not ask anybody about the incident. I have no personal knowledge with regard to how kerosene was poured on Khudeja.
Hmm.
It should be Nureja, Lord. And how she caught fire and died. husband of my niece told me earlier that Nureja was ill-tempered by nature, and she used to quarrel over petty matters and go to the house of her aunt, my house. So this part your lordship will find subsequently also.
Oh.
After her marriage, I visited the house of my husband, of my niece twice and found Nureja in happy conjugal life. And she did not tell me
Ill
ill
about the
about
accused.
the accused. Subsequent to the death of Nureja, the accused eloped with Fatima, sister of Nureja, and married her. Deceased Nureja's mother left her husband, went to Karnataka with one person, got married and lived there. Nureja's mother and I did not visit the house of the accused after Nureja's death. Nureja's mother did not come from Karnataka after her death, but Nureja's father came to the janaza funeral prayer of Nureja. The scribe did not read over the contents of the Ejahar to me after writing the Ejahar. I went to Nureja's house after my sister made phone calls to me twice. The OC of the PS questioned me. It is not a fact that I did not tell the villagers that I heard about the incident from villagers. I do not know whether the accused is in visiting terms with his father-in-law. It is not a fact that I lost the case bringing false accusation against the accused. So this is the evidence of informant. Now PW2 is the father of the victim. Page 11.
Yes.
And his evidence was brushed aside by the learned trial court on the ground that accused remarried the younger sister of the deceased because of that. Because there were two minor children, one was 5 years, one was 3 years. So therefore, he had to remarry the.
Now,
her
please read
sister.
this.
I know the accused. I know complainant Maleka Khatun. She is the elder sister of my wife. The accused is my son-in-law. Deceased Nureja Khatun was my elder daughter. The incident took place about 1 year back. The incident took place in the house of the accused at Kharguli, Habigao under Dolgao. I went to Guwahati forest at the time of incident. Around 8 a.m., the accused informed me over phone that
Galanodi, not Guwahati Forest. Galanodi, not Guwahati.
I went to Galandi forest. I'm sorry.
Where is Guwahati Forest?
That because of that Kharguli word, the problem. I'm
Is
sorry.
there any forest in Guwahati?
No.
We don't think so. Okay, he came to Galanodi Forest.
Yes,
Then
I went to Galandi forest at the time of the incident. Around 8 a.m., the accused informed me over phone that my daughter Nureja Khatun, Nureja got fired. Since I was not well, I asked the accused to take her to hospital. Around 3 p.m., I somehow reached Mangalore Hospital and came to know that my daughter Nureja was no more. Police questioned me. My wife's elder sister lost this case. Police visited visited the house of the accused and did interrogation. I do not know why Malika had lost the case. I did not ask her to lose the case. Nureja left 2 sons. My wife and I got separated about 12-13 years back. My 2 daughters live with me. Presently, the boys live with their father, that is the accused. After about 5 months back, I married off my other daughter Fatima to the accused. So PW1 said that eloped, but their father said he married off. Nureja's elder son is about 6 years old and the younger one is about 3 years old. Exhibit 1 is the inquest report and Exhibit 1.1 is my signature therein. Cross. I do not know what police had written after questioning me. I do not know how Nureja caught fire and died. Later, I came to know from the villager that my son-in-law, the accused, was innocent, and that sometimes he used to beat herself out of anger. She did not state anything about her husband, and it had been about 8-9 years of her marriage. Maleka did not tell me why she had lost the case. In fact, I married off my other daughter to my son-in-law as I had not found any fault with him. Prior to her death, Nureza and the accused came to my house and told that they would come on the following day also. I went to their house. This is the evidence of father.
He has not been declared hostile.
Yes, sir.
Yes, PW3.
PW3, Mamoni Begum. He is the neighbor, adjacent house. I know the accused. He is my neighbor. This is Nureza Begum was also my neighbor. I do not know the complainant. The incident took place about 1.5 years ago back. It has been about 8-9 years of the marriage of between the accused and Nureza. They have 2 sons. Quarrel took place between Nureza Khatun and accused very often. Around 6:30 a.m. on the day of the incident, Nureza Begum asked for 100 rupees from the accused, and a quarrel ensued from it. Nureza herself poured kerosene and set fire. So this part, Lordship may see that Nureza herself poured kerosene and set fire. I went to the place of occurrence after that. At this stage, prosecution witness is declared hostile at the prayer of prosecution side. I stated to police in such terms, it is true that assault was made for dowry. I saw quarrel taking place at about 9 a.m. on 5/10/2017 and fire after the quarrel. At that time, the accused, that is her husband, was sitting outside. Nureza died because of dowry. It is true that kerosene was burned. Kerosene was poured and fire was set. I saw when she was lying burned. She was taken to medical hospital very late. It is not a fact that since the accused is my neighbor, I have adduced false evidence concealing the truth. Cross. At the time of the incident, the accused was sitting on the road. After the fire had caught, the accused and I rushed there and tried to put it out, and Nureza was able to speak. When asked, Nureza told that she herself poured kerosene and set fire to her since she was not willing to continue with the conjugal life with the accused. I have been residing near the house of accused for 2 years since after marriage. Once Nureza tried to commit suicide by striking her head with a dao. I did not see the accused torturing Nureza. It is not a fact that I had stated to police that the accused tortured Nureza and that Nureza died in dowry-related incident. The accused brought ambulance and took the injured to medical hospital. At the time of Nureza's death, it was about 8-9 years of the marriage between the accused and Nureza. PW4. Victim's maternal uncle's daughter.
Who is she?
She is victim's maternal uncle's daughter. Neighbor also.
Yes.
I know the complainant as well as the accused. The incident took place around 7 a.m. on one day about, about 1.5 years back. Our house is situated near that of the accused. The name of the wife of the accused is Nureza. Nureza married to the accused about 1.5 years ago prior to the incident. About 6 months of their marriage, the accused started assaulting Nureza in demand of cot, bed, and other articles. So this is after 6 months, and marriage she died when her marriage was about 8-9 after conjugal life of 8-9 years. One day, on the day of the incident, quarrel took place between Nureza and the accused. Thereafter, fire caught Nureza. Hearing a hue and cry, I rushed to Nureza's house and saw that the upper portion of her body got burned, and the portion below her waist was not burned. Nureza was asking for water. Nureza was shouting that she did not set fire to herself, and that it was other person who set fire to her. Thereafter, the villagers took Nureza to Dolgaon hospital, and she was not kept there. She was taken to Mongoldoy hospital. Nureza died after she was taken to Mongoldoy hospital. So she was taken to initially taken to Dolgaon hospital, although they did not keep her, but they could have written that dying declaration, but that was not done by the hospital authority. Cross. Nureza had two children, one aged about 2 years and other about 1 year at the time of incident. I was not present in Nureza's marriage. Nureza is my paternal cousin. It is not a fact that I did not state to police that demand was made for cot, bedsheet, etc. Tukur Pepari's house is situated in between the house of the accused and mine. The house of the accused is about 100 meters away. I did not hear how Nureza caught fire. It is not a fact that Nureza did not shout, I did not set fire to myself. Somebody has set the fire. When I went to see her, it is not a fact that I did not state to police that around 7 o'clock quarrel took place between Nureza and the accused. I found Nureza inside the house of the mother of the accused. The house of the accused is about 150 meters away from that of his mother. On my arrival, I found the fire on Nureza's being put out. The accused and other villagers were present there. Letter says, the accused fled away after the incident. Mother and mummy, wife of maternal uncle of the accused, took Nureza to hospital by an ambulance. I did not go to the medical hospital. I informed my mother and she informed Nureza's parents about the incident. Although Nureza's father came to hospital to see her, she had breathed her last already. It is not a fact that I have deposed falsely that Nureza was married of about 1.5 years back, that she had a 1-year-old son and a 2-year-old son, and that cot, bed, etc. were demanded. It is not a fact that I have deposed falsely that somebody had set fire to Nureza. It is not a fact that Nureza was not willing to continue her conjugal life with the accused, and that she herself set on fire to her. No case was instituted with regard to the demand of dowry because the accused did not allow, but extrajudicial trial was held in the village. The papers of the meeting are not available with me. It is not a fact that I have adduced false evidence.
But this PW3 has not made direct implication against your client.
Lord.
She has said that she could hear the deceased shouting that she did not set fire to herself and it was some other person. So who is that other person has not been uttered by her?
At the same time, Lordship will see that if a person is burning, whether she will cry for help or she will say that I have not burned myself, somebody has
No, it can be said.
that part, Lordship,
It-
because
that-
she did not
That
went to
cannot be
the-
totally ruled out that she'll not say that.
No.
Obviously, there would be a tendency to say, if somebody has set me to fire, if I am
if
in my,
somebody goes close to her.
yes, she had gone close to she asked about water. She
Right.
asked for water. Then she said, I did not set myself to fire, some other person.
Other
Who's that other person has
That-
not been
that is not there.
specified. Okay.
PW5, Rafil Ali, he is the neighbor. There were 4 houses in between his house and the thief.
Neighbor of the, which one? Accused?
Yeah, accused. Accused.
Okay. Please read.
I do not know the complainant. I do not know the accused. He is my neighbor. He is neighbor, but it is said that I do not know. I have just checked. It is there in Napao. In Assamese also it is. I do not know the accused. He is my neighbor. The accused is Nureja's husband. The incident took place around 9 a.m. one day about 1.5 years back. At that time, I was at home. Hearing a hue and cry that fire had broken out, I came out and went to the house of the accused. On my arrival, I saw a person operating a tubewell and the accused pouring water on Nureja. So he was there, he was pouring water. They were outside the house of Nureja. Entire body of Nureja got burned and only a little cloth was sticking to her body. When the villagers came out, the accused fled to Jannatul's house. Nureja told that she did not set on fire herself. Her husband did it.
Oh,
Later, the mother of the accused took Nureja to near the road to take her to hospital. Later on, I heard that the mother of the accused took her to the hospital and she died there. Quarrel took place between Nureja and the accused daily, and the latter assaulted the former, demanding dowry. 3 days prior to the incident, the accused caused crack in the head of Nureja by assaulting her. When Nureja went to lodge a case, the villagers brought her and make a settlement between them. Cross. When I went to the place of occurrence, I found Nureja able to speak. I found Hasina Begum at the place of occurrence. I did not witness how fire caught Nureja. I heard from Hasina that the accused assaulted Nureja in demand of dowry. Though I did not see the accused assaulting Nureja and thus causing fracture on her head on the road to my house 3 days prior to the incident. I saw her going in injured condition. About 15-20 minutes before the occurrence of quarrel took place between Nureja and the accused in the house of the maternal grandmother of the accused. The house of the maternal grandmother of the accused is situated 3 houses apart the house of the accused. I do not know the name of the maternal grandmother of the accused. I heard that quarrel had taken place, but I do not know what the quarrel took place for. On my arrival, I found Nureja outside the house of the accused. The house of the accused and that of his mother is 240 feet apart, and there was cultivation in between. The accused has two sons, about 5 years and 3 years old. I do not remember whether I had stated to police or not that on hearing a hue and cry, I came out and went to the house of the accused and saw a person operating a tube and the accused pouring water on Nureja, and that when the villagers arrived, the accused fled to the house of Jannatul. I do not remember whether I told to police or not about Nureja telling that she did not set fire to herself, but her husband did it. About making assault in demand of dowry, about causing fracture in the head of Nureja by the accused, and about the settlement made by the villagers when Nureja went to file a case. I do not know after how long of the marriage this incident took place. It is not a fact that today I have adduced false evidence in the court.
What does the IO say on this dying declaration regarding PW 5?
Um, Page 30, your lordship will find
30.
30.
Yes, please.
Israfil Ali did not depose before me that while the village people came to the place of occurrence, accused person fled away to the residence of Jannatul. Israfil Ali did not depose before me that Nureda had told him that she had not self-immolation. Her husband burned her down. Physical assault due to demand of dowry. And prior to the aforesaid incident about 3 days ago, her husband assaulted her head on her head, and while she went to lodge criminal case against her husband, the village people prevented her from doing so and for amicable settlement.
Why you are asking? Because yesterday, if you remember, we had hinted about the fine distinction between an omission and a contradiction. Whether it's a proved contradiction. Here, in the cross-examination, she had something in between. She doesn't remember telling before the police regarding the dying declaration. And this appears to be proved by the IO's deposition that such statement was indeed not made.
No.
She had not said that, yes, it's not a fact that I did not say. She
Yes.
said, I do not remember.
Yes.
She was not very sure. So it is between omission as well as contradiction.
Basically, he's not denied by.
Yes, please proceed.
PW6, Tukur Ali. He is also neighbor of accused.
Yes, who is PW6? What is his name?
Tukur Ali.
Interesting name.
Not that famous Tukur.
Maybe, who knows? Maybe.
This is from Doron. He's from Doron. But
Must have temporarily shifted there. Best is when we hear him speaking English. Yes, next. PW6, Sukur.
PW6. I know the informant. I know the accused. I knew Nureja Khatun. Accused is Nureja's husband. Houses of the accused.
Neighbor.
Neighbor.
Yes. Yes, please proceed.
Houses of the accused.
Mine are adjoining.
Minor.
Hmm.
The incident took place at about 7, 8 a.m. One day, about 2.5 years back, 2 to 2.5 years back, at the time of incident, I was sitting by roadside near my house. At that time, Nureja came and asked for rupees 100, saying that she would go to her father's house, and when the accused gave her rupees 50, an altercation took place between them, and then they went to their house from.
He has also been declared hostile.
Sorry.
Yes,
Uh,
thereafter, please proceed.
yes. I'm reading in spite of those, they were declared hostile because your lordship will find in that 313 also, he took the same plea that on that day, he asked for 100 rupees and as he was not having 100 rupees, he gave her 50 rupees. Thereafter, some altercation took place and he went to outside. There immediately thereafter, this incident occurred. So this finds corroboration in with 313. An altercation took place between them and then they went to their house from the road. About 1 hour thereafter, hearing hue and cry, my wife informed me that a fire broke out in the residence of Moidul, whereupon I ran to the house of the accused and saw Nureja in flames. Later on, she was taken to the hospital by ambulance. At this stage, prosecution witness is declared hostile at the prayer of prosecution side. It is not a fact that I stated to police in such terms. Quarrel often takes place between the accused and Nureda Khatun. About a month ago, he caused crack in the head of Nureda by assaulting her. Parents say separately. The accused assault her for dowry. We have seen it. At about 9 a.m. today, that is 5/10/2017, quarrel took place which resulted into assault. Due to this, kerosene was poured on Nureda Begum and fire was set to her. It is a proof that the accused set fire to her. We went there. We sent the injured to the medical hospital. Quarrel took place at about 9 a.m. on 5/10/2017. Thereafter, I came to know that fire was set to her and the victim died. It is not a fact that I have adduced false evidence for the sake of the accused. I had not stated to the police whatever I have deposed today in the court to have stated before the police. I did not see how fire caught Nureja's body. I reached the PO when the ambulance came there. I in Assamese it is written that মই বেলেগৰ পৰা পাকঘৰৰ জুই লাগি মৃত্যু হৈছে. So that is gap in between. Page 22 last line.
What is it? Moi belegor pora?
বেলেগৰ পৰা পাকঘৰৰ জুই লাগি মৃত্যু হৈছে. So here also incomplete. Probably he came to know from others that the fire broke out from the kitchen and caused the death.
But the hostile portion that
Got
which he had denied,
Got
the IO says something else at page 30 regarding Sukur.
Yes. That regarding
This one was PW6 was Sukur.
Sukur.
It is not a fact that he has not told the hostile part.
Yes, that allegation is there.
What? Yes.
PW 7 lordship. Lalvano Begum, wife of PWC.
Yes, please.
I know the informant. I know the accused. I knew the victim Nureja Khatun. Accused is my neighbor and husband of Nureja. The incident took place at about 1.5 years back. The incident took place in the house of the accused at about 8-9 a.m. on the day of the incident,
Occurrence.
the day of the occurrence. Nureja asked for rupees 100 from the accused, and when the accused gave her rupees 50, Nureja tore the currency note. About 5-10 minutes thereafter, fire broke out in the house of the accused. I went there and saw Nureja in burned condition on the courtyard to the house of accused. She was able to speak.
Yes.
At this stage, prosecution witness is declared hostile at the prayer of prosecution side. It is not a fact that in my statement given to police, I stated in such terms. I came to know that quarrel took place at about 9 a.m. today, and kerosene was poured and was set in of the quarrel. We ourselves went there. We sent the injured to medical hospital, and she had sustained burn. Quarrel often takes place over the issue of dowry. They live separately from the paternal family. It is true that fire was set. It is not a fact that while giving statement to police, I stated the way mentioned above, and that today I have adduced false evidence for the sake of the accused to save him. Cross. I did not see the burning. I heard from children that Nureja herself had set the fire. After quarrel had taken place, Nureja went towards the house and accused went towards other direction. I did not state to police whether I have deposed today in court to have stated to the police. Page 26 is the evidence of the doctor who conducted postmortem. So that is admitted that she died due to burn injury and cross was declined.
Yes.
From the postmortem report, one thing I just want to point out to Lordship that regarding that kerosene, that pouring kerosene, that kerosene smell or something that is not there. Only burn injuries it is there.
Where is the report?
Lord,
Where is the report?
page 26,
No, this is the deposition.
report. Postmortem, your Lordship will find at page 79. And no scissor list was exhibited in the present case to show that that kerosene can or something was seized from the place of offense. No scissor list was seized. Because allegation is that kerosene was poured on her. Is it not?
Okay. Yes.
When PW9 is the investigating officer.
Are you?
Ayo.
Yes.
One thing if I may point out, here inquest is written as Exhibit 1 in the evidence of PW2, but I could not find it in the paper book. So may I ask my learned friend to check in the record, Lordship, if it is there?
Exhibit 1 is the PM report.
No, in the here your Lordship will find in the deposition.
Doctor says that PM report is Exhibit 1.
Page 12, Lordship may kindly see of the paper book. Page
12.
page 12.
Yes.
Page 12. Last line of PW2 of chief examination in chief. Exhibit 1 is the inquest report and Exhibit 1 is my signature there. So in subsequently also that postmortem was marked as Exhibit 1. That is probably wrongly at page 27.
Okay, doesn't matter. We'll sort this out. We'll sort this out. You
Now,
proceed.
now paragraph 48 of the judgment, Lordship may kindly see. Regarding
Page?
that inquest was not there in the record. Paragraph 48 of the impugned judgment and in the paper book, your Lordship will find page 56.
Yes, which part?
In the instant case, there is no any inquest report of the
No,
dead
no,
body.
paragraph
Paragraph 48.
48. Yes,
In the instant case, there is no any inquest report of the dead body of the deceased. The investigating officer, in spite of the fact that the deceased died in unnatural way, had not done the inquest of the dead body. Only the postmortem of the dead body was done. So the court has no any option but has to depend upon the postmortem report regarding cause of death. I have gone through minutely in the postmortem report of the deceased, which was done by Dr. of Mohaldas Civil Hospital. So regarding this, this observation was there. I was only pointing out because of the fact that in the postmortem report, there is no mention about smell of kerosene oil. But in the similar that inquest report is also not there to justify that there was smell of kerosene oil. And my ladder friend also checked in the record, it is not there. PW9 is the investigating officer at page 28.
yes,
On 5/10/2017, I was at Dolgaon Police Station as a SI of police. On that day, after receiving the Ezahar lodged by the complainant, the officer in charge of Dolgaon PS registered a case being number 666 of 17 under section 498A of IPC and entrusted the preliminary investigation to me. Exhibit 2 is the Ezahar and Exhibit 2.1 is the signature of OC Dolgaon PS, namely Jagadish Sharma. After getting the charge of investigation, I came to know that the victim was produced before the Mangalore Civil Hospital for medical treatment. But on the same day, she had expired. Immediately, I came to the Mangalore Civil Hospital and took necessary steps for postmortem of the dead body. On 6/10/2017, I went to the place of occurrence and drew a sketch map of the place of occurrence. Took the statement of the witnesses. Exhibit 3 is the sketch map and Exhibit 3.1 is my signature. I had taken some photographs of the deceased while I had visited the Mangalore Civil Hospital. On the same day, I had made a prayer before the CGM Dorong for adding section 304B as the victim already expired. And on the same day, after getting the permission from the Honorable CGM Dorong, I had added the section 304B against the accused person. The accused person was arrested in connection with the instant case and forwarded to the Honorable Court. I had collected the postmortem report of the victim and after getting sufficient material against the accused person under section 498A 304B of IPC, Exhibit 4 is the charge sheet and Exhibit 4.1 is my signature. I had taken the statement of Mamoni Begum, PW3. She deposed before me as it is true that she was assaulted due to dowry. Today, that is on 5/10/2017 at about 9 a.m. in the morning, I had seen a quarrel had taken place and thereafter saw the burning. At that time, accused, that is her husband was sitting on the outside of residence. Due to the reason of dowry, Nureda was murdered, and it was also true that by pouring kerosene oil, she was burned out. I had seen the victim with burned while she was lying in her house in that condition. she was taken very lately to the hospital. I had taken the statement of Tukur Ali. He deposed before me as accused always engaged with quarrel with Nureda Khatun. About 1 month ago, he caused head injury to deceased Nureda Khatun. The parents of the accused lived separately. Accused physically tortured the victim for dowry and we had seen it. Today on 5/10/2017 at about 9 a.m. in the morning, quarrel took place and thereafter kerosene oil was poured on the body of Nureda Khatun and thereafter she was burned out. It is a fact that accused set ablaze the victim. We went there. We sent the injured to hospital. On 5/10/2017 at about 9 a.m., quarrel had taken place and thereafter she had set ablaze the victim by later on. I had taken the statement of Lalbanu Begum, PW7. She deposed before me as today at about 9 a.m. in the morning, quarrel had taken place and thereafter, after pouring kerosene oil, she was set ablaze, which I came to know. I went there. The victim was sent to hospital. Quarrel took place due to demand of dowry. Accused lived separately from his father. It is a fact that victim was burned. Cross. Maleka Begum had not deposed before me that she heard about the matter from the village people, but deposed before me that Torifa Khatun had informed her about the matter over phone. It is not a fact that Mamoni Begum had not deposed before me about the hostile part as I narrated before this court today. Hasina Begum had not deposed before me regarding demand of the accused of khat and paleng from the victim. Hasina Begum had not deposed before me that victim told her that she had not herself set fire, but someone else. But deposed before me that accused set fire on her body. Hasina had not deposed before me that on the date of occurrence at about 7 a.m. in the morning, a quarrel had taken place between the victim and the accused person, but told before me that at about 9 a.m. in the morning, a quarrel had taken place between the victim and the accused person. Israfil Ali did not depose before me that while the village people came to the place of occurrence, accused person fled away to the residence of Jannatul. Israfil Ali did not depose before me that Nureda had told him that she had not self-immolation. Her husband burned her down. Physical assault due to demand of dowry. And prior to the aforesaid incident, about 3 days ago, her husband assaulted her head, and while she went to lodge a criminal case against her husband, the village people prevented her from doing so and for amicable settlement. It is not a fact that Tukur Ali had not deposed the hostile part as narrated by me before this court. It is not a fact that Nurvanu had not deposed the hostile part as narrated by me before this court. As per contention of the FIR, the incident took place at about 8 a.m. in the morning. It is not a fact that I had not done the investigation properly and filed false charge sheet against the accused person. Now, 313 your Lottie will find page 31.
Yes.
Question number 8, Lordship may kindly see page 32. That the appellant himself informed his father-in-law about the incident. Then your lordship may see question number 9 regarding that quarrel part.
Yes.
PW3 Mamoni Begum deposed in her evidence that you had frequently quarreled along with your wife Nureda Khatun in your residence, and on the date of occurrence at about 6:30 a.m. in the morning, your wife asked an amount of rupees 100 from you, and relating to this a quarrel had taken place. What do you want to say? Yes, on that day my wife asked me to give her rupees 100 as she desired to go to her parental home. But due to non-availability of money, I gave her 50 rupees. Then your lordship may kindly see question number 12. Further, PW4 further deposed in her evidence that thereafter the incident of burning upon Nureda, deceased, had taken place, and due to hue and cry, she ran to the residence of Nureda and found her burning of the upper part of her body. What do you want to say? False. She had not gone to my residence at that time. Question number 14, but she will find. PW5, Israfil Ali further deposed in his evidence that on the date of occurrence, while he was in his residence, at about 9 a.m. in the morning, he heard hue and cry and came to the residence and saw that you had been pouring water on the body of your wife. What do you want to say? Yes, at that time Malika was fetching water from the tube well, and I had poured water on the body of my wife to douse the same. In question number 19 also he stated about quarrel regarding 100 rupees. That about PW6 evidence. And he has given his explanation at question number in respect to question number 22, page 35. On the date of occurrence, victim asked me 100 rupees to go to the residence of her father, but due to non-availability of 100 rupees with me, I gave her 50 rupees, due to which an altercation took place. Thereafter, my wife went to the residence and I stayed in front of the residence of my house. And that moment, I heard hue and cry from Mamoni, who came to me, who called me to come to my residence. Then I rushed to my home and saw my wife causing burning at the time, and both of us tried to put the fire from the body of my wife. Thereafter, my wife was taken to Mohaldo Civil Hospital for medical treatment, and the attending doctor, after giving the preliminary medical treatment, referred the patient to Guwahati for better medical treatment. And unfortunately, she died on her way to GMCH. My wife died due to self-immolation. So he has given his explanation. Here, one thing my submission would be, Lordship, that he was convicted under section 302 and he was acquitted under section 304B and 498A. And under section 302, there is no presumption. So prosecution have to prove its case beyond reasonable doubt. Had it been a case of 304B, then presumption would have come.
The 304B and 498A
Sorry.
have been, the discussion is there in para 74. The date of the marriage is a crucial one.
Sorry.
And there is evidence that the incident had happened after 8 to 9 years of the marriage.
Sorry.
So that those presumptions which
Yeah.
are found in 304B will be out.
Yeah.
So yes, otherwise also will for 302 conviction, it's the duty of the prosecution to prove beyond all reasonable doubt.
Those circumstances, your lordship will find paragraph 54 of the impugned judge. 45, sorry. Page 55. Page 55 of the paper book, paragraph 45 of the impugned judgment. So basically, the circumstance of quarrel has been taken by the trial court. That is why I said, Lordship, that if P04B is not there, that presumption will not come. Only because of that quarrel, probably he killed, that presumption will come. That is why.
The presumption is not necessarily connected with a quarrel.
No.
Presumption, even without a quarrel, if it is within 7 years, dying out of unnatural circumstance, including burn, 304B may come in. Whether there's a quarrel or not will not be material. So you have to make an endeavor that the materials which have been proved or which are on record will not be sufficient to constitute an offense which has been proved beyond all reasonable doubt. Who are the witnesses against you?
These are the circumstances which is
The informant,
before.
number one,
What
she is almost a hearsay.
Here.
She is the informant she heard regarding the incident from the mother of the victim who was in Karnataka.
Yes.
Mother did not come. She informed over telephone. Thereafter, even before meeting the victim in the place of occurrence, she had gone first to the Thana, lodged the FIR, and in the meantime, the victim had passed away. So she is neither a witness to any dying declaration, nor there is no eyewitness as such till now, direct. So one may not be a very relevant witness. Two, I don't think he is implicating your client, father of the. He in fact said that married the other daughter and did not find any fault with the accused. And he has also in the cross-examination said that I came to know from the villagers that the son-in-law, the accused, was innocent.
And one more thing he said also that the victim was having tendency to harm herself. That part. That cross page 12, second, third line. Look.
Page?
Page 12. It starts from second line of cross process. Later, I came to know from the villagers that my son-in-law, the accused, was innocent, and that sometimes she used to beat herself out of anger.
Sometimes. What is this? Can you check the vernacular?
Yes.
Maybe it could be some double.
নুৰেদা কেনেকৈ জুই লাগি মৰিল নাজানো। পিছত গাঁৱৰ মানুহৰ পৰা জানিব পাৰিছো যে আছামী জোৱাইক কোনো দুখ নাই আৰু তাই মাজে মাজে খঙতে নিজৰ গাত নিজেই কোবাইছিল আৰু মৃত নুৰেদাই তাইৰ গিৰিয়েকৰ বিষয়ে একো কোৱা নাছিল।
It's okay.
I think you should inflict.
No, it doesn't matter. Kubaisil. Bit. Yes.
This is the evidence for you. My submission for your lordship is that chain of circumstance is not complete in the present case. Because from the evidence of witnesses, it has come out that accused was there. He tried to douse the fire. he took the victim to the hospital. And prosecution failed to seize any sort of kerosene oil, can of kerosene oil from the place of occurrence. And inquest is also not there to show that at that time of at the time of inquest there was smell of kerosene.
PW5, however, at page 18, he talks about a dying declaration.
Just one line that is there.
And he has also said that when the villagers had come, the accused has fled away.
But that part, Lordship, that the investigating officer says at page 30, that was not disclosed to him during investigation. Israfil Ali, page 30 of IOS evidence.
It is of course. I know. Yes, what are your submission? What are your grounds?
First thing, Lordship, my ground is that the chain of circumstances are not complete in the present case. And the absence of motive
But was the date of marriage proved?
not proved.
Not
Yeah,
5,
the
6 years,
8,
8, 9.
9 years.
5, 6 years will be against you.
8, 9, 8,
Marriage,
8,
8, 9.
8, 9,
But was the date of the marriage
not proved.
proved? No.
Not
So that presumption automatically will not come unless it is specifically proved
proved. Proved by
that the incident had occurred within 7 years of the marriage.
Yeah.
So, and there is no cross appeal by the state. So we are outside the purview of this appeal.
Okay.
You are only concerned of your conviction under 302.
30.
And there is no direct evidence in the form of eyewitness. So it is circumstantial. So you say that the circumstances do not form a complete chain. That is your
That
submission.
is, and the prosecution also failed to prove the motive of the appellant to cause the incident, because in circumstantial evidence, they have to prove that motive part. Motive assumes important in circumstantial case. If it is direct evidence, then motive may not be relevant.
Now, there are case laws, even in circumstantial evidence, lack of motive may not be the sole factor.
But facts of the case, Lordship, may is that husband and wife, there has to be some motive.
Within 6 months of the death, he had married her sister.
Not 6 months, Lordship, that before 6 months of deposition, not within 6 months.
Deposition was within 1 year.
After 6,
Hmm? Within 6 years of the death, he marries the sister.
because minor children were there, because father also.
That is
said-
your explanation.
Lot.
Then
And he himself tried to douse the fire. He did not flee away from the place of offense.
there is evidence that he fled away. There is another evidence that he tried to douse the fire and
If two views are there, that accused will get the benefit.
But who said? Somebody said he fled away.
Yes, that was.
PW5, Israful.
Yeah.
When the villagers came, the accused fled.
But prior to that, because that even then, if we accept.
What is this contradiction of the IO on this line? When the villagers had come, the accused had fled. PW5
That part he has not stated.
not stated.
What?
Only the dying declaration part.
That also not stated.
No.
Regarding dying declared.
No, during declaration, there is a contradiction. IO
Yes.
says that it was not. What about the fleeing part?
That also.
Where?
Page 30, Lordship may kindly see.
30.
Easy. Rafael Ali did not depose before me that while the village people came to the place of occurrence, accused fled away to the residence of them.
Okay.
And in cross also he was asked about the same, and he said, I do not remember, at page 90. Seventh line from bottom.
Okay, and
And then Lordship will find that in the present case, no material is there to show that kerosene was used in the instant case. No material was seized from the place of occurrence. Inquest was not there. Inquest is not there to show that smell of kerosene was there. Postmortem report is also silent regarding this.
yes,
These are my submissions for you. And he is already in custody since the date of judgment. Lordship, that more than around 5 years he is in custody till now. More than 5 years. He was date of judgment is Lordship. He was taken into custody on 2/3/2020.
yes, madam.
PW 4 lot. Hasina Begum. It is the relevant
Page,
page number 15 lot. 1.
yes, please.
From 5th line lot.
Hmm.
On the
Mhm.
day of the incident,
Hmm.
quarrel took place between Nureja and the accused. Thereafter, fire caught Nureja. Hearing a hue and cry, I rushed to Nureja's house and saw that the upper portion of her body got burned and the portion below her waist was not burned. Nureja was asking water. Nureja was shouting that she did not set fire to herself and that it was other person who set fire to her. Thereafter, the villagers took Nureja to Dolgaon Hospital, and as she was not kept there, she was taken to Mongoldoy Hospital. Nureja died after she was taken to Mongoldoy Hospital. That is the PW9 IO. IO statement Lordship, page number 29 Lordship, down portion Lordship, in the cross
29,
29. The cross part Lordship.
yes.
Hasina Begum had not deposed before me regarding demand of accused of Khat and Paleng from the victim. Hasina Begum had not deposed before me that the victim told her that she had not herself set fire but someone else, but deposed before me that the accused set fire on her body. Hasina had not deposed before me on the date of occurrence, the time Lordship, the 7 a.m. in the morning, a quarrel had taken place between the victim and the accused, but told before me at about 9 a.m. in the morning, a quarrel had taken place between the victim and the accused person. So it is very clear, Lordship, that Lordship, quarrel was there, Lordship. And right from the beginning, Lordship, after some years of marriage, quarrel was there. And even all Lordship, regarding the head injury, Lordship, that Lordship PW,
Let us see this 161. I think the recording may not be correct. Of Hasina.
But just I'm pointing out to Lordship that PW4 was not declared hostile. So they have to go by the evidence what they have deposited for the court.
Hasina,
Hafsina Begum।
yes.
ইয়াৰ পিছৰ পৰা সুখৰ বাবে পদকীয়া মহম্মদ মফদুল
Just read that part regarding setting on fire.
সংযম পাঁচ, 10, 17 তাৰিখে ৰাতিপুৱা 9মান বজাত যৌতুকৰ বাবে কাজিয়া পেচাল ঘৰৰ বাহিৰ কৰি দিছিল আৰু কাজিয়া কৰি ঘৰৰ ভিতৰতে কেৰাচিন তেল ঢালি জ্বলাই দিছিল। আমি গৈ দেখা পাওঁ আৰু নুৰেজাই পদকীয়াই জ্বলাই দিয়া বুলি কৈ যায়। মেডিকেলত পঠাই দিওঁ।
Okay, Noreja had told.
নুৰেজাই
Noreja
পদকীয়াই
is the deceased.
Yes. আৰু নুৰেজাই পদকীয়াই জ্বলাই দিয়া বুলি কৈ যায়।
Yes. Yes. Mhm. So how do you reconcile? We have a statement made by PW4 before the police, 161. We know how much is the evidentiary value of 161. So if we come to the substantive evidence in the doc as PW4, she is not so specific. She says that the setting on fire was not done by her, but by the other person. Name is not there. Now, in the cross-examination of the IO, not in his chief examination, I do not know why this cross-examination was put to him. He said that before me,
You have said that husband have
PW4 has said that it was the accused who had set on fire. So how much would be the evidentiary value of this?
It's the fact that he have said that somebody have burned. Other person have burned. In that regard also, in 106 evidence dot, there was in the house only husband and wife dot. There was no other person. Also. The husband have not explained also how the fire got to. In that regard also, he have not given any appropriate reply to that, but that how she have got fire, because it is up to the chief. He will know, Lord. Only he and his wife is there, Lord, and quarrel was there. And regarding the fracture of head also, Lordship, in question number 18, he has said he has-
Fracture of head was some days
Due to sleep
before.
Lord.
Some days before.
that also he have said in question number 18, Lordship, that yes, there was head injury.
No, if so far as that part is concerned, we have got evidence that PW3, I think, testifies that she was sitting with the accused on the road.
Right.
When the deceased had come asking for 100 rupees, he gave 50 rupees.
50.
She got infuriated, she tore the currency note and went inside. And thereafter, the fire incident had taken place. And she also testifies that she had drawn water from a tube well and he was trying to douse the fire, the accused. Those are also there.
And so Lordship, he also fled away, but not revealed in the iota.
And what about
In
the,
that part
what,
of the Lordship,
what about the use of kerosene? What investigation, what evidence
that
is there?
Lordship, there is no seizure is done. Lordship.
No
Seizure is,
scissor,
seizure list is only not there.
no scissor is done.
No seizure list. That is Lordship.
No inquest also done.
Was not done, seizure not done. But Lordship is
Before the PM was done, inquest would have been done at least in the hospital. What was the dead body looking like? At times, inquest report really helps.
not
And in this case, the PM report, whether
only upon the depending on the case.
examination,
But
but smell of kerosene would have come in the
the
inquest.
inquest report, or if it is seizure is done, Lordship, to FSL also.
So what do you say?
Regarding this Lordship, as PW 3 also says, but they are no doubt hostile Lordship, but regarding her three lit-
PW3,
PW 3 also Lordship,
Mamoni.
Mamoni Lordship.
But Mamoni said that Nureja had herself poured kerosene. PW3 may not help you because
Lordship, she was done hostile, but Lordship, PW 3 Lordship, I stated to the State Lordship, page number 14, I stated to the police in such terms, it is true that assault was made for dowry. I saw quarrel taking place at about 9 a.m. on 5/10 so and fired after the quarrel. At that time, the kerosene was burned, kerosene was poured, and fire was set. But we have not mentioned who, but kerosene was poured. Lordship, PW 5 also said same thing, Lordship. Page number 18, Lordship. Last, but Nureja told that she did not set the fire on herself. Her husband did it. PW 5, Lordship.
no 5, this will not be admissible because there is a contradiction.
That is contradiction with the
Contradiction, and he in the cross examination he says that I do not remember whether I have said this.
Mm.
If you would have said yes, I have said this before the IO, then it would not have been a proof
Sure.
contradiction. Now this turns out to be a proof contradiction.
There was a quarrel for which Lordship settlement was also going on between her and the villagers at a meeting, Lordship, because in page number 19, Lordship, about causing fracture in the head of Nureja by the accused, and about the settlement made by the villagers when Nureja went to file a case. Page number 19.
Here 306 was not he was not charged under 306. Even if it is taken to be suicide,
But that is not
1306 was not.
put. So Lordship, the explanation by the husband is also not proper enough. Because only no other person, but only he and his wife.
Where is the discussion in the impugned judgment regarding implication or application of 106 of the Evidence Act? Is there any?
Lordship.
Hand of the paper.
Yes.
Was the house of the accused. Lordship, in is also complete because there is frequently quarrel between the circumstances between them, Lordship. The victim was taken by mother and the sister of the accused.
Bridget. Mhm. See, cross-examination of PW1, page 9. Third line from the bottom.
Nureja and the accused at the time of the incident. I do not know what the
Third
quarrel,
line from the bottom, the husband
the husband of my niece
is
and his
and his
relative to-
relatives took Khudeja to Mohaldo Civil Hospital. Husband too.
cross she told, but while she have heard about the incident, Lordship, she was at the police station. It's not
No, in the cross-examination, this
Cross-examination
is her
but-
deposition. That husband along with his relatives had taken the deceased to the hospital.
as the fellow villagers of Khudeja's husband told me about the incident.
Yes.
I got tense and first I went to the police station and lodged the Ejahat. After the death of my niece, Nureja, I did not ask anybody about the incident. I have to personally regard how the correct told me.
Anything else, madam?
Depending on the evidence of PW4 and PW5, but the fiction may be updated because the PW4 corroborates with PW9.
Okay. We'll close this. Anything you'd like to add or what?
That addition, that judgment.
Citation, you should give along in your, not in your reply, you should be, yes, what are your citations?
That regarding that, what they have proposed in the court, or that it is binding on the prosecution, that,
That yesterday,
yesterday, those citations,
say what is the thing? Give,
Uh, just I'm giving one copy, two copies.
name.
That Raja Ram versus State of Rajasthan.
Yes.
Paragraph 9.
Paragraph, citation?
That is Lordship,
Yeah.
AIR online 2000 SC 474. Paragraph 9.
What is the,
That prosecution
Basis?
is bound by its own with.
okay.
Regarding circumstantial evidence, Lordship judgment that
That yesterday I've given,
Monica.
Monica Koti. Monica Koti, you should refer to Sarada Birji Chand.
that your judgment was quoted here, and that Rina Hazarika's judgment also regarding 106 and explanation given in 313.
Rina Hazarika citation?
AIR 2018 Supreme Court 5361.
Huh?
5361.
Proposition?
That is on that section 106 of Evidence Act and section explanation given by accused in 313. How this paragraph Lordship 3, 4, 8, 16 and 17.
Okay. Oh. We have heard H.R. Chaudhary or whomever you say. Okay.
He was here.
Word H.R. Chaudhary, Senior Counsel, assisted by Sri Ahmed and A. Begum, APP, huh? Conclude code. Okay.
Avlai,
এইখন তাতে থৈ দিব লাগিব। এইখন কি আছিলে? মনটো কি হৈছিলে? Item number 9 is also yours. Today my brother has to rise early.
That's why, but let it,
Okay, we'll give some date. Item number 1 to কি আছিলে?
Yes, your lordship, I didn't find anything as regards 313, but there's the order dated 22/11/2023 of this honorable court.
Now,
Wherein
what
this-
was the learned counsel saying? 313. He was not properly briefed. Where is he? And it's a 14 matter. The 11 years have passed. Doesn't make any sense. We'll have it next week. Let him be fully equipped.
may I pray for, lordship, I don't have a copy of,
Of paper book. Paper book you have to make a photocopy.
may I get it from the court?
Photocopy এটা করাই লব। Photo করাই লব। না না তেওঁলোকে করাই লব। করাই লব। You have to make a photocopy
I'll do
as
it.
an exceptional thing. Otherwise we are not supposed to part with any records. Okay. Item number 1. On request, list after a week. Yes, next. এখানে লাগবে এইটো এইমাত্ৰ কেছটোৰ। যোনটো শুনিছো এইটোৰ আগৰটো আছে। Next.
Six,
I pick it.
item 6.
Item number 6.
Mr. Gupta was. It's that.
Item 6. Mr. K.L. Gupta, Mr. S.K. Ghosh.
Pick it.
ডেটটা দিয়ে দিব হ্যাঁ ডেটটা দিয়ে দিব নেক্সট
7 and 8.
7, one is criminal appeal, another is death sentence reference minor.
Yes, Mr. Gupta, where are you? Your matter has been called upon. Where is your colleague, Mr. S.K. Ghosh? Anything has happened in the meantime? Any development?
my party agreed to lump sum payment of 12 lakhs rupees. At an earlier date, 25 lakhs to ask for the alimony, We ready to make payment one time at the beginning.
Well, what about, is there any agreement?
He has not told it. Their demand is very much. They are asking for 30.
We give a date then, huh? We'll not record anybody's absence because both the councils were on request.
Next date, 1 week, next week. Next
On
week.
request list after a week. And this also 7. Mr. Kamar, anyone?
Vijita is there for the criminal appeal.
We'll have both this matter together. On request list after a week. Same order. Nine to control.
Date may be
Nine, a prayer for adjournment has been made, comma. Matter of which year?
24.
24. At least for hearing after 2 weeks.
Lordship, date may be fixed. Otherwise, it will not be.
It will come 24 matter. There are other old matters also.
And we have behind the bar, my lord.
All are behind the bars. There are old matters also.
But there is no in the eyewitness, my lord. This is just a circumstantial evidence.
Every case is important. Cannot be. Okay.